Oh, hello, YouTube world. Hey, welcome, Veterans Day, KV employees, everybody watching. Hey, always glad that you're here, whether it's your first time or you're a repeat offender. Hey, don't forget to subscribe, like, share, all that good stuff as you feel fit. I want to continue growing this channel where we educate about VA disability claims, and we make the process ultimately easier between VA and veterans and everybody involved. Hey, as always, I'm Attorney Matthew Lang, VA accredited attorney, here to talk about some VA disability, my favorite thing to do on terrific Tuesdays. So, what do we got today? Well, as you've probably seen from the title of the video, is we're going to talk about the evidence listing section of the rating decision. Now, we've done a video before where we talked about the rating decision and we briefly discussed this. But I want to go in a little bit more detail because I think we can, as a whole, find some other mistakes, some other errors that are occurring that unfortunately, from my experience, have occurred for numerous years, that we can really kind of hammer out and help the process as we improve in the way business is ran. Hey, before I do that though, we've been out in the public last couple of months here. I want to give a general thank you to everybody who has invited us, who's welcomed us into their events, where we have been able to meet other veterans, meet other family members, meet other people who provide some services that may be able to be beneficial to veterans here out in the public. It's been fantastic to be able to be out in the public, to be able and do all this, to get to know everybody. We hope that at some point we not only get the word out of what we're able to do to help veterans, but to be able to provide other resources to veterans when we hear that, hey, I hear you may need this, and we happen to know of somebody. So it's fantastic. Look for us again. We're still moving across the valley here in Phoenix area. I think we've done quite a bit now on the west side. Eventually, I imagine we'll be moving to the east side a little bit more. And we'll start stretching out even more so from the valley here. I've already been out to New Mexico on an Albuquerque trip as well, and was very gracious of being welcomed there and talking and having the opportunity to talk to veterans there. Love hearing the stories and love helping out. So just want to put that general thank you out there. I didn't get approval to really get anybody's names on the video, so I'll make it general here. But thank you to everybody out there. All right, let's talk about that evidence list. So we know one thing for sure by now, right? That we're working with a complex legal framework when it comes to VA disability. But we're also talking about a portion of that complex legal framework that involves the decision-making process. Complex or not, the idea here is that this framework that's inside of the United States Code, that's in this Code of Federal Regulations, it's in court cases and other references, is really designed to protect the rights of veterans. So I want to really highlight that here because I'm really concerned that sometimes this may get lost in interpretation or forgotten about along the way when trying to make a decision and making sure that everything is covered and you meet all your goals and standards and so forth. So I get it, complex legal framework. It's a lot to know, it's a lot to learn, but let's get some of it out there. Now, previous video, again, we talked about the evidence listing a little bit, but let's go through some of that again really quick before I get into my few examples here that I think we can do better with, in my professional opinion, actually. So when we look at the rules, the laws, the manual, VA's manual here, we really come down to what the manual's really saying here in general. The evidence section is a listing of each piece of evidence considered in arriving at the decision. That's what it is. It's a section that's a listing of each piece of evidence considered in arriving at the decision. Now, law really makes note that the provisions mandate the decision must include a detailed statement of the evidence. So there has been some arguments back and forth in the legal community that I've heard about the idea of a listing and a statement and the difference between that and maybe how that doesn't quite fit for what we see today in the law based upon the manual. I'm not going to get into all that there. That's not what I'm here about. Let's just go ahead and say, for the sake of this video, that listing and statement it's just going to be the same thing. We can hash out all those other things later on. But whether we call it a statement or a listing, it's evidence that's considered and explained of how the evidence supports the final rating decision. So we know from the manual and what we've talked about a little bit before that there's all kinds of types of evidence out there. So the manual does include and says it's not limited to, and it gives a few listings here: service treatment records, service personnel records, private and VA treatment records, VA or contract exam reports to include disability benefit questionnaires, lay statements, written or oral testimony. So it's not an all-inclusive list, nor can it be, because we got all kinds of evidence that can come into play. But keep in mind, that's what we're trying to do. We're trying to list the evidence on a rating decision and then explain it. Why is it there? Why was it considered? What about that evidence persuade the decision maker to make the decision that they did? Maybe the evidence wasn't persuasive to change their mind from what they did, and that's part of the discussions as well. So the highlight here is, outside of the idea that this is a list of evidence, I want there to be an understanding, and I'd like there to be an understanding, that this is not, even based upon the words of the manual here, a list of everything in the record. This is not a list of CYA. This is not a list of, well, if I put it down, maybe they won't deem me on quality. I'm saying these things out of experience, unfortunately. I have been there. I have unfortunately made those same mistakes myself, and I really wish I could go back and fix those. For now, since I don't have a time machine, I can't go backwards. But what I'd like to do is continue improving and fixing those mistakes as we move forward. So here we are going to point some of this out. Understand that what the rules and laws are really telling us is that this evidence section statement or listing is not just a standalone piece of the rating decision. In fact, the rating decision, none of it is a standalone piece. It is all one, ultimately. The evidence listing must be integrated into the decision narrative as well. We can't just say, I've listed all the evidence in the file and therefore I've done my job, and not talk about any of that. What did you consider? When we get into the rules of that narrative, we really start seeing that open up and what the law says underneath the code and what the courts have said there. What is that evidence that you speak of in this listing and in a statement? Why did you consider it, VA? Why was it relevant? What was it persuasive? Was it unpersuasive? Which way did it make you lean? These are very important. This is another reason this cannot be a listing of all the evidence, because if you didn't consider it, well, you're probably gonna have a hard time talking about it, in my opinion. But I will leave that as it is. So I think the main point I want to get off with this before I go into these examples is that the legal expectation is that every relevant or material fact in the decision is traceable to an entity on the evidence list. Ultimately, you want to ensure that the administrative record can withstand scrutiny in a judicial review process. But you also want to make sure that it can be understood by the veterans. Veterans need to understand why you made the decision. If they look at this evidence list, they've got to understand, did you look at all the evidence? They've got to understand why you considered that evidence. They've got to understand why the evidence was important, why it was relevant to you, the decision maker. They got to know that you actually reviewed all the relevant evidence. We're going to go through some examples where it's very, very vague and won't let the veteran know what was even a file at the time the decision was made. So ultimately, VA, what happens here is the veteran's forced to continuously submit the same thing, potentially over and over and over and over and over again, and because they have no indication that the relevant evidence that they submitted was even considered in the claim because it was written. So I imagine everybody's curious by now. Let's talk about some of these examples here. I'm going to tie these in with the VA manual here. It's a very short little section with the evidence list, actually. It does have a table in here, which is kind of nice. It is I suppose, a guideline, so I suppose nothing has to be perfectly listed the way this does, but might not hurt. Again, it doesn't talk about everything. It can't. I understand that. I get it, but I think it's very helpful. There's definitely pieces that are being missed, I feel, in the rating decisions, and so I want to help out there too and provide that education out there as well. So what are some things I see? Well, these are things I've even seen, again, when I was in the VA, when I was a decision maker, things I was taught to do, things I did, things I thought were right at the time without understanding and not having the experience I have today. So what were some of those? Well, it wasn't uncommon, and I still see it fairly often today, to write in the evidence list, review of all the evidence of record. So what did we just talk about? So are you saying you considered VA all the evidence of record? And if so, why did you not talk about any of it in the narrative? By the way, when the veteran looks at this, can you understand how vague that description is? I myself in VA, I know you do too, you can see the record. At least I can for those that I represent. But veterans don't have that unless they usually file a FOIA request, Privacy Act request of sorts. So how do they know what evidence was of record that you considered at the time? How do they know? I point that one out because as we look through the way everything is listed on here, I don't see anything that allows for, in your manual, that allows for a review of all evidence of record as a statement. In fact, it would seem that the intent is completely opposite of that. We find that everything is broken down from service treatment records to service personnel records where there's dates involved, there's an identification of periods of service, there's treatment records, whether it be from a VA facility, identifying what periods those are covered. I mean, everything's broken down. So if you have, I would presume, if you have evidence in that record that you truly reviewed, and considered as part of this decision, then that would include private medical records, that would likely include lay statements, that would likely include other VA examinations. So based upon the way the manual here is written, it would seem that the intent is that all that has to be spelled out. So I do note that. This, I would say, is 100%, in my professional opinion, in my legal knowledge here, completely against the rules, against the VA's guidelines. So anytime I see that one, veterans do know my first thought is I'm appealing because somebody I don't feel reviewed the record. Unless they actually talk about all that evidence in the file that they reviewed. Maybe they reviewed it, but I'm going to tell you that screams to me, and I'm just going to give that little tidbit out there, but that's how I review it. That screams to me somebody got sloppy, and it's what it is. Didn't review actually the whole file, slapped it on there because they thought they were covering themselves. Like I said, I've been there, I've done it, and I know that's what I was doing when I did it. And I wish I could still, again, go back and change that and say that I never did that. But I will take the ownership of the mistakes I have made as well. Here's some other stuff we see here. VA letter dated, and it gives a date. That one I find interesting as well. I see it quite often. There's nothing in the guidance that really talks about the letters, but I do kind of question what if the VA wrote the letter. Typically, the letter is informing the veteran of something that was needed, maybe, or notifying the veteran of a decision, perhaps, because I also see it listed as notification letter dated. If that's the case, I'm really curious from my perspective, and VA, I could probably use your help on this one. Actually, as I'm really curious to how that fits into the guidelines in the way that why it would be considered. Now, I can think of, honestly, one where maybe why the notification letter had been considered, but I think likely that scenario I'm thinking of would be the rating decision, a previous rating decision, really, and the evidence that was relevant out of that, and we're going to talk about that one too. But I think it's interesting because a lot of VA letters, again, just give information. So what was relevant? What request did you make to the veterans that made you decide to deny a claim or grant a claim? What was in your letter that persuaded you? think it's a fair question. Hey, here's the other big one that I see that definitely goes against, for the most part, the one for sure here. One example could be iffy, but it definitely goes against the VA's manual here. So this one is important. And again, this is one I've done myself back in the past, and I wish I never would have now that I understand things the way I do. But I still see it constantly today. Rating decision dated, and there's the date. Now, the only time a rating decision really should be considered as evidence, from what I understand, is if the condition that's being appealed, was being appealed because it was denied before, or maybe there was we're talking about an effective date or an evaluation. Essentially, it was addressed before. So that would make sense if there was something in that decision that persuaded you, be it one way or another, on how you decided the claim, moving forward, how you decide that appeal. But what I take note with that one is, again, it's not ever listed in the narrative typically. Now, sometimes I see the conclusionary statement. It just will regurgitate what that decision said. And okay, I get that. So I can work with that scenario. But let me give you this next one first really quick. And then we're going to talk about how this one for sure and the other one may not really fit your own guidance, and how we should probably be on the lookout for it to help make it a little clearer. So I have seen ones that don't just say rating decision and the date behind it. I have seen rating decision with parentheses behind it and a statement inside those parentheses that say including all relevant evidence listed, and then it gives the date of the decision. Well, I'm back to not knowing what was relevant and what was in the file. It's like saying review of all evidence of record. It's just more creative, maybe. It's like putting the review of all evidence of record and the rating decision one all together is one instead of separately. I'm pointing this one out because this is actually completely 100% against the guidance in the manual here. So let me find that one again here. We have in the manual, here we go. So in this chart here, it lets you know if the evidence section identifies evidence considered in a prior decision. So it does, right? It says all relevant evidence listed on that decision. So it's demonstrating to me, and likely the world here, that evidence considered in a prior VA decision. So how is that supposed to be listed? What's wrong with this? It says then list the evidence type by separately stating each piece of evidence considered in a format consistent with the table's guidance, kind of like what we talked about before. It only really, I feel, in this guidelines tells the VA again the intent of the way this guideline works is every piece of evidence considered must be well described. Because again, I don't know if I'm the veteran, if what's included on that. What did you find relevant on that last decision? And ironically enough, I was fascinated with this one when I seen it. I went back, and each time I went back on when I seen this one, I found the previous rating decision said the same thing, except it would list 2 or 3 more decisions, and then the same thing. So then I get confused going, if you found even 300 or 400 pieces of evidence relevant, why are none of them talked about in the narrative as they should be by then? What did you truly consider? But again, veterans don't know what was in that record. They can't see it. So how are they supposed to understand it? So I just want to point these out because I think we can definitely make improvement when it comes to following the guidelines that are in the manual in order to help meet the criteria of listing evidence that's considered and understanding how the rules and laws work in this complex world, in this complex framework, in the fact that the evidence listing or statement is not a standalone piece of the rating decision. It's not designed to just list a bunch of evidence, just say you listed it and then move on. So I got one more here that I'm going to ask the VA for help on. We're going to make kind of some fun light of it. But veterans, if you see any of these, again, veteranline.com, go to my page there. Consider scheduling a free case evaluation. Let's talk, because I'm fairly certain, highly certain, that you have an appeal issue because somebody has not actually reviewed evidence from what I understand and have seen, when I see stuff like this in a rating decision. So I would definitely consider getting it reviewed for an appeal and getting that representation. Again, it's a free case evaluation. My calendar's on my website, veteranlane.com. I'm not here to just sales pitch myself. There are other representatives out there. If you have a representative, a VSO, another credit agent or attorney, feel free. I would say go check with them and see what their thoughts are as well. Maybe they've had the same experience with this and have the same opinions, and maybe they don't. But I would say you should definitely consider an appeal on a claim as soon as you see something like that, and especially if you don't see that evidence being discussed in the narrative. All right, so VA, I'm going to ask you for help on this one. I'm going to make a little light of it, because this has been my most entertaining piece of evidence listed. So I'm a little confused. Now, for everything we went over, we're talking about relevant evidence. Evidence is considered in light of the decision that helps you get to that decision. Stuff that should be discussed about in the narrative, right? Well, I'll admit, I got a little perturbed when I seen this, because the interpretation that could be taken from this, and it concerns me, the interpretation that can be taken from this. Now, eventually I finished reading the evidence list and realized, again, what we had here was somebody listing every piece of evidence on the record. Remember, you trained me, VA. I'm pretty good at knowing what I'm looking at. So, here's what it was. For all you dying for me to tell you, here's what this piece of evidence was. In the evidence list, this was the listing. VA Form 21-22A, appointment of individual as claimant's representative, and then I gave the dates. For those who don't know, when I represent a veteran, being an accredited attorney, when we get to that point in that discussion and we decide we're moving forward and we can do something to help the veteran here in their pills or filing of new claims, and we decide to go on record, VA Form 21-22A is a mandated form to notify the VA that I, as the accredited attorney, have been appointed by the veteran as their representative on their VA claim. So, VA, you may know where I'm going right now. I'm hoping there's a little chuckle out there, because this I didn't look to see who did this. I'm not concerned about who did this. I can see all that, sure. But I'm not here to point fingers. I'm here to make light of a situation and say, hey, can we correct this, please, for the benefit of the veteran? The listing of the VA Form 21-22A, which again is that appointment of myself or another accredited individual, agent, attorney, or a VSO, who is helping the veteran out. I can't think for the life of me how that's relevant in why you denied a claim or granted a claim. Why did you use that to make your decision? Why did you consider that? Remember, when I go back, and this is where I got a little heated, because this is how I felt that this could be interpreted. And since I don't know the intent of the person, I can't say it's how it was interpreted for sure, but it could have been. So keeping in mind, remember, the manual here, the M21-1, says that the evidence section is a listing of each piece of evidence considered in arriving at the decision. So if you used this mandatory form for veterans to appoint a representative, you considered that in their decision. I can only assume when you denied them, well, I can take the interpretation that when you denied them, that the only piece you considered out of that in denying them is the fact that they have a representative, that they used an attorney. And if that is a true depiction of that listed as the evidence, oh boy, VA, we got really big problems. You're not supposed to be biased. You're not supposed to have your personal feelings involved in these rating decisions. They even put it in the law, which crazy they had to go that far. But just know that that is an interpretation I seen that can be taken from it. I'm trying to help you out, BA. I don't want anybody yelling and screaming and saying, hey, you denied me only because I had a representative. But anyhow, again, from my experience, when I read through the whole evidence list, I realized it was just a list of all the evidence of record. So we got away from stating review of all evidence or rating decision, including all relevant evidence or things like that. And actually, sure, I give them credit. They listed the stuff as the intent of the, for the most part, the intent of the manual here and the rules and regulations. But yeah, to say you considered the appointment of an individual in denying a veteran. I'm willing to ask for help. Maybe I'm missing something. Maybe my interpretation is a little off the wall. Maybe it's not. I don't know. Could be interesting to see the comments. Keeping them clean, of course. I'm not here to cause a fight. I am just kind of curious on why that's relevant. Because I'm missing it somewhere. So, educate me. I'm here to be educated too. Anyhow, everybody, we'll get off that. We'll quit making light of that. Mistakes are made. I get it. It's easy to do, especially when you're working in such a large realm of laws and rules and guidelines. But let's see if we can do better. These are just a few highlighted ones I see pop up constantly, ones I've seen happen year after year after year after year that the manual has tried to fix, really even says, hey, that's should not be in there in the evidence list. So I want to bring that up. So hopefully we can definitely make that correction and then kind of bring up the idea that yeah, you should probably make sure you're only listing things you're considering that are relevant to a claim. So because you've got to also see how that looks and how that understanding can come across. Everybody, I always appreciate you. I really do. Any topics you want to hear about, please leave them in the comments. I will keep finding topics. There's plenty out here to talk about. I'll keep making videos and we'll keep posting them. But if there's any special topic you want me to get to sooner than later, yeah, let me know. I'll do some research if I need to. I'll find you what I can and we'll make some videos. But until then, I'll see you next Tuesday where we talk about more VA disability. Have a wonderful day.